If you're not a lawyer, what's the difference between questions of law, of fact, and mixed questions? Let's start with a real-life case. Suppose a bodyguard shoots bystanders. Who is liable and why? This actually happened on the 1st of December 2016. The case is called the GMP Kaiser case. This is what happened. A man called Jaafar was a bodyguard. He was employed by a security company. The company gave him a loaded Glock pistol. The idea was to protect the client called Dato Ong. 2 days into Jaafar's job, Ong was driving his car on the Tun Dr. Lim Chong Yu Expressway, you know where? Penang. Jaafar accompanied him. While in the car, for some reason, Jaafar shot and killed Ong. The car crashed. Jaafar alighted from the car. He then started firing at random into the public. Meanwhile, a gentleman by the name of Amirul was a photographer. He saw the accident. He stopped the motorcycle to help. He approached Jaafar asking, "What happened here?" In answer, Jaafar shot him point blank, severely injuring Amirul. Amirul later sued the security company, and the question before the court was Jaafar's employer responsible for Jaafar's act? Is it a question of law, you think, or of fact, or a mixture of both? And most importantly, how do courts go about deciding such tangled questions? This was a case called the GMP Kaiser Security Sendirian Berhad versus Muhammad Amirul Amin Muhammad Amir. There the federal court had to sift through exactly these problems. So was Jaafar acting in the course of his employment, or was he on a frolic of his own, as law sometimes puts it? The answer would determine if the security company, as Jaafar's employer, was vicariously liable for Amirul's injuries. What's vicarious liability? Vicarious liability means an employer is liable for the employee's conduct. Start with questions of fact. The first task for the court is to work out what actually happened. Who shot whom? Whose firearm was used? Was Jaafar supposed to be there? Did the security company arm him and assign him to duty on that day? These are all questions of fact. They deal with what lawyers call WH questions. What, when, who, where, and how. The trial judge hears witnesses, looks at documents, and decides what to believe. In this case, the following was as clear as a bell. Jaafar was indeed an employee of the company. He was acting as a bodyguard. He had used a firearm to shoot Amirul. That weapon was issued by his employer so as to fax all the boxes checked. Now move to the questions of law. Now comes the big legal question. Is an employer legally responsible for such an act? Is this a question of law? It is. It focuses on what the law says. The courts had to look at what legal concept of vicarious liability meant, and they had to ask themselves, can an employer be held responsible when the employee's wrongful act is so closely connected to the job, such as being armed by the employer, that it creates a risk to the public? This isn't about whose version is right. It's about which legal principle controls the outcome. But what about the twisty bits? So enter mixed questions of law and fact. Here it gets tricky. Was Jaafar still in the course of his employment when he started shooting randomly? Or did he cross the line into personal madness beyond his job description? Here, the facts and the law are intertwined. Does Jaafar's rampage count as closely connected to his work as a bodyguard, given he was placed there by his employer with the gun provided by them to protect yet ended up harming innocent people. This is the classic mixed question of law and fact. The judge or court must first decide the facts, second, fit the facts into the legal test, often involving 50 shades of grey and reasonable judgment. How did the court resolve it? The federal court said, by equipping Jaafar with a weapon and placing him in a position of trust. The company had created the risk. Jaafar's action, although criminal and catastrophic, flowed from the very risk the employer had introduced to the public. The act was so closely connected to his job that his employer was vicariously liable. So what is the difference between what happened, question of fact, and the legal rule, the question of law, and the application of the rule to the many events, mixed questions? That was central to the answer. How and why does it all matter? Well, first, because such types of questions have their own consequences. Questions of fact are usually decided by the trial judge who hears the evidence. Appeal courts rarely interfere because they don't see or hear the witness unless the facts are wildly misunderstood. Questions of law can always be appealed against because courts want the law to be clear and uniform. Mixed questions are the main battleground of lawyers and judges, and appeals only succeed if the trial judge fumbled in formulating or applying the correct legal test, even if the facts are in themselves accepted. Let's bring in Malaysia Kini, Tony Poa and Irene Fernandez. In the 2021 Malaysia Kini's contempt case, the issue was whether the online portal was responsible for comments made by users. What did Malaysia Kini do was a question of fact, right? Is a news portal legally liable for what other people post? That was a question of law, right? And most critically, does the law applied to these facts make Malaysia a publisher defined by statute? That's a classic mixture of fact and law. Then go to the 2019 Tony Poa's legal saga. There the federal court had to decide whether the Prime Minister was a public officer, liable for misfeasance, giving money away or taking money away. There were facts, what Najib actually did or allegedly did, and law, is he a public officer? The court's job was to untangle both with many mixed questions along the way. We now come to 1990. A genteel elderly lady, Irene Fernandez, was charged for what? Allegedly false news. She had reported the detainees in immigration detention camps were abused. She faced the court's judgment on what she actually said and whether that breached the law. What exactly did she publish? That was a question of fact. Did that amount to an offense under the law? That was a question of law. And in applying the legal standards to her conduct, the court confronted another classic blend of what? Fact and law, mixed questions. By the way, you'd be interested to know she had to appear in court 310 times. In 2003, she was found guilty. Can you believe it? After 15 years, in 2008, she was acquitted. This great heroine of human rights passed away in 2014 as resolute as ever. So now we come to the secret formula lawyers called WH plus L. Here's your GKTV law tip. When you see a legal drama or a case, start with the WH list. Who, what, when, where, why, and how. Get your facts straight. Then add the L. What's L? What's the law? What's the legal rule? How is it applied? Finally, combine both. The facts meet the legal threshold. Did they? Then you come to judgment. So, the practical tip is, when you read a judgment or hear about a case, train your eye and your mind to spot which paragraphs lay out the facts, which explain the law, and which combine both. Suddenly, the most complicated cases make perfect sense. Remember, for justice there must be finality. Findings on fact are rarely overturned, but the decisions on the legal tests, on questions of law, keep evolving through appeals, and mixed questions keep our judges and our lawyers up at night. These distinctions are not just academic. They shape who wins and who pays. So next time someone asks what the real difference is, try this. Facts are the bricks, the law is the blueprint for the house, and the mixed questions are the cement, and how they all fit together to build a structure of justice in Malaysia. Now, I hope that made sense. Have a good day. Goodbye.